Hello? The law passed in the state of Florida that gives fathers equal parental rights. In other words, an unwed mother no longer has sole custody and visitation. We will discuss these laws. And at the end of this presentation, we'll give you some strategies in which to challenge the child support process. Because remember, child support is voluntary. In Florida, the law that was passed affects custody and visitation. For example, House Bill HB 775 to provide equal rights to unwed or single fathers. Next, House Bill HB 1301 affect parenting and time sharing of minor children, and we'll discuss that. This is great news for fathers.
The governor has signed House Bill Hatch 775, granting fathers who willingly acknowledge paternity the same rights as unmarried mothers. This ensures equality and legal protection for unwed fathers to nurture, care for, and financially support their children. This bill aligns with the Parental Rights Amendment, affirming a child's right to be raised by both parents unless it's detrimental to their best interests, upholding parents' fundamental rights to make decisions about their children's upbringing without government or third-party interference. Previously, Florida lacked penalties for unmarried women taking their children out of the state without consent from the unwed fathers, creating ambiguity in defining fatherhood legally. For instance, an unwed mother could claim sole motherhood even if the biological father supported the child financially.
This is a joyous moment for father in a custody issues the state of Florida. House Bill 1301. The parenting and time sharing of minor children. The proposed changes aim to simplify the process of modifying a parenting plan or time-sharing schedule by eliminating the need for an unanticipated change in circumstances. The new measure establishes a presumption in favor of equal time sharing for the child, which can be challenged with appropriate evidence. When creating or modifying a time-sharing schedule, the court is required to assess specific factors and provide detailed written findings of fact as part of the decision-making process. These adjustments seek to enhance the efficiency and clarity of the process while prioritizing the best interests of the child involved.
Whether you're married or unmarried, you have an equal chance to challenge custody and visitation. Remember, the laws that passed is in alignment with the Constitution, your 14th Amendment right.
The 14th Amendment. No state shall make or enforce any laws which shall abridge the privileges or immunities of citizens of the United States. No state shall deny to any person within its jurisdiction the equal protection of the laws.
In this presentation, we're dealing with single fathers. However, we have another video called Marriage Guide to Custody and Visitation. Please preview that video. Preview my video, why I started my channel on child support education. There is a lot of misinformation about the child support process, whether it's federal program or a state program or a little bit of both. I break down step by step how the child support works. I have another video called The History of Child Support, Why Fathers Are Not Happy. Preview that video. This is a reality check. If you're battling for custody, then my suggestion, you need to have in your paperwork the D.O.J. letter of 2023. You can file it into your family court case. Let's discuss the law that was passed in the state of Florida. However, there's a maximum of law that says ignorance of the law excuses not, then ignorance about the law excuses no one. And the case law is State versus Miller, June 9, 2017. Hello, My name is Chris, and in this session, we'll discuss custody in the state of Florida. Let's get started. You can also listen to us on our podcast. We're available on all the major podcasts, Spotify, Apple, and Google. Also, we ask for a donation. Yes, we are asking for a donation. All this research that we're providing, it takes time and energy, and we're just asking for a small compensation just to keep our channel going. And if you have as small as a $5 Cash App, we're welcome. We're asking for a $25 gift donation, but again, any amount will be accepted. The law which was passed in Florida must be litigated before an Article 3 court. However, child support is Article 1 court, which is administrative court, and Article 1 court is not a part of judiciary powers. So Chief Justice Marshall says that these courts are not a constitutional court, and the case law is Northern Pipelines Construction versus Marathon Pipeline, as well as Ducero versus United States. This issue versus Article 1 versus Article 3 is somewhat confusing, so I have another video that's called Understanding Jurisdiction. Article 1 and Article 3 determines the jurisdiction. Jurisdiction is the cornerstone of our judicial process. Without it, the judge cannot make a decision. I have another video that discusses child support and custody. Check out this video. The law that was passed is in alignment with the Supreme Court. But remember, states must obey the decisions of the Supreme Court and cannot refuse to follow them. And it's called, the case law is Coopers versus Aaron, 358 U.S. 1. Also, under the Supremacy Clause, state courts have concurrent duty to enforce federal laws according to regulations and procedures. And the case law is Coughlin versus Houseman, 93 U.S. 130-93. What is the meaning of fatherhood?
As a father, I am the natural guardian of my children, responsible for their care and upbringing, and have the right to enjoy their company and benefit from their efforts. However, this authority is considered a trust given to me by the law, based on the assumption that my natural affection for my children will ensure I fulfill this duty faithfully.
In order to take advantage of these new laws, it starts with acknowledgement of paternity, which is you're the father, you're the DNA father. And you can do that on your own terms. You can do it privately as well. You don't have to involve the courts. When you go to court, they'll introduce you to what is called the Acknowledgment of Paternity. I downloaded this site on the DHS website, and I cannot give you any legal advice, but you need to pay attention to this form. The Acknowledgment of Paternity form, pay close attention to what is called the Acknowledgment by Natural Parents. Again, I can't give you legal advice, but pay close attention to this form. There is a statute called the Establishment of Paternity, and the statute is 45 CFR 303.5, where it says that voluntary acknowledgement of paternity. However, if the mother is on food stamps or government assistance or welfare or Medicaid, then Section 2, that it's only voluntary. Remember, you have access to the court at any time.
The right of access to the courts is basic to our system of government, and it is well established today that it is one of the fundamental rights protected by the Constitution. I have the right to access the court at any time. This means that legally, a document is considered filed at the moment it is delivered to the clerk, even if it hasn't been officially marked as filed yet. This principle ensures that my ability to engage with the judicial system is not hindered by administrative delays or technicalities. The right to access the courts is a cornerstone of our system of government. It is a fundamental right that is firmly established and protected by the Constitution. This right guarantees that I, along with every citizen, have the ability to seek justice, challenge injustices, and have my voice heard in a court of law. It underscores the importance of an open and accessible judicial system as a key component of a fair and democratic society. The case laws are Biffle versus Morton Rubber Industry and Rilland versus Shapiro.
When you're in court, you can plead your case by yourself. And the U.S. Code is 28 U.S.C. 1654. It reads, "In all courts of the United States, parties can plead and conduct their own cases, whether personally or by counsel." It's perfectly fine. You can plead your case on your own. If you are conducting your case on your own, then the clerk must accept your paperwork. The clerk cannot refuse to accept any court papers solely because it lacks the form or procedures or by practice. And that's Federal Civil Procedures, Section 5D4. And the case law is Biffle versus Morton Rubber Industries. So a clerk must accept your paperwork, whether it's handwritten or you could type it, but they must accept your paperwork. When you are litigating custody, the custody battle, the judge may recommend that you get an attorney. However, the judge cannot say that I'm going to force an attorney upon you, because why? You can litigate yourself on your own. You just need to know the laws and rules. And the case is called State versus Pendleton or Moore versus Michigan State. When you are in a custody battle, I suggest or recommend Stanley versus Illinois.
In Stanley versus Illinois, the United States Supreme Court considered whether a state law presumption that unmarried fathers weren't fit guardians violated the Constitution. Peter and Joan Stanley lived together off and on for 18 years and had 3 children together. The couple never married. When Joan passed away, the state of Illinois took custody of the Stanley children based on a state law that presumed unmarried fathers weren't fit guardians for their children. Illinois law had processes in place to take children into state custody on the basis of neglect or dependency. For neglect, the state could remove a child from the parents following proper notice, a hearing, and a finding that the parents were unfit. Dependency removal was permitted if a child had no living parents or guardians. The dependency statute defined parents in a way that excluded unmarried fathers. Therefore, Peter wasn't considered to be a surviving parent, and his children were taken into state custody without any notice or finding that Peter was an unfit parent. Pursuant to a state dependency hearing, Peter's children were declared wards of the state and placed with court-appointed guardians. Peter appealed, arguing that he'd been denied his rights to constitutional due process and equal protection. The Illinois Supreme Court affirmed the guardianship proceeding.
As a parent, I have the fundamental right to raise my child, just as my child has the inherent right to be raised by me. This bond between parent and child is deeply rooted in our connection, and it reflects not only a responsibility but a cherished privilege. I hold a vital interest in the care, upbringing, and custody of my child, ensuring that they grow in a loving and stable environment. At the same time, my child has a parallel right, an important liberty interest in not being unjustly removed or separated from our family. This right safeguards their emotional and developmental well-being, ensuring that they remain with the people who know and love them most. Any unjust interference with these rights is not just a personal affront, but a violation of the 14th Amendment of the United States Constitution.
If the courts are not honoring your rights, then you have a right to sue.
The right of access to the courts is basic to our system of government, and it is well established today that it is one of the fundamental rights protected by the Constitution. I have the right to access the court at any time. This means that legally, a document is considered filed at the moment it is delivered to the clerk, even if it hasn't been officially marked as filed yet. This principle ensures that my ability to engage with the judicial system is not hindered by administrative delays or technicalities. The right to access the courts is a cornerstone of our system of government. It is a fundamental right that is firmly established and protected by the Constitution. This right guarantees that I, along with every citizen, have the ability to seek justice, challenge injustices, and have my voice heard in a court of law. It underscores the importance of an open and accessible judicial system as a key component of a fair and democratic society. The case laws are Biffle versus Morton Rubber Industry and Rilland versus Shapiro.
Every person who, under color of any statute, ordinance, regulation, custom, or usage of any state or territory subjects or causes to be subjected any citizen or other person within the jurisdiction of the United States to the deprivation of any rights, privileges, or immunities secured by the Constitution and its laws, is liable to the party injured at law, suit in equity, or other proper proceeding for redress. In any lawsuit brought, the plaintiff must prove that he or she has been deprived of a right secured by the Constitution and laws, and secondly, that the defendant was acting under color of any state law.
If you are concerned about the battle for custody, schedule a consultation. If you have any questions or comments, please feel free to reach us at chrish@289.protonmail.com. Also, subscribe to our YouTube channel and hit the notification bell. We ask for donation because we do extensive research material, and it takes time to review and select the appropriate relevance. So we're asking for $25 donations or any amount.